Happy November. Whatever you do this month, don't feed the trolls or the feds. Don't let them feed you. Don't take the bait. Don't play with fire, but burn whatever bridges you need to burn. Oh, and thanks for being my neighbor. You can cross my bridge anytime you want, unless you're a fed.
I need to dig in, and you all need to dig into exactly what is the problem with each one of these issues. All right, so let's talk about the schedule. Okay, the state asked for this, some disclosures of witnesses, expert witnesses, exhibits by May 3rd. I don't think that's particularly practical at this moment. I know that you had, I'm not looking at it right now, you got another idea about that, Ms. Taylor?
Judge, I think I had May 7th.
Okay. That seems more practical. Okay, so I will put an order out, schedule order for providing, I don't know if the state really knows what you do until you see what they have. And you're shaking your head, yes.
Yes, sir.
And that means that maybe you don't have any witnesses, expert reports, or exhibits at this point because you don't know what to expect. And this is related to the hearing on the 16th, right?
In the 14th, I'm not sure.
Okay. And there may be witnesses on the 14th too, as well?
Yes, Your Honor.
Okay. All right, so let's make it May 7th for disclosing witnesses, expert reports, and exhibits. We'll see what the state has to do with that, and we'll have a response maybe May 10th. Is that sufficient?
Okay.
It's tight.
Well, that gives us 3 days to respond.
3 days. Yeah, that's right. Well, May 10th is I don't know when I'm going to read all this stuff too, because it's 14th. So if I don't have it by the 10th, then you're saying the 13th. I guess I can do that the night of the 13th. But also, the defense needs some space there too. And I don't think we want to push out that hearing. Can't do it by the 10th.
We have no idea what the defense plans on doing, and that only gives us 3 days to read, comprehend, and respond.
We'll deal with it. We'll deal with it the 13th then.
Yeah, I mean, we can try, and then if we need more time, we'll ask for more time.
It's just then on my end, you're looking at, I'm going to have really more, I'm going to need more time.
Your Honor, I don't expect reports. I expect to provide a witness list.
Okay.
I don't expect there to be reports.
Exhibits?
There may be exhibits. I think there will be at least 2 or 3. I know some will be things that they've already given us in discovery, so they shouldn't be new and surprising.
Okay. I mean, it's hard to have these tight, time frames because we also have other things to do, but. Mr. Thompson?
Your Honor, it's completely unfair and unacceptable for us to get a list of witnesses with no idea what they're going to testify about. We're just, the names witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case of last-minute disclosures of witnesses and PowerPoints and all sorts of things that frustrate Your Honor's ability to assess what's going on because it's brand new to you, just like it's brand new to us. And I think that practice has to stop. We need substantive disclosures. If they're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just a name. So what's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
Okay, well, I mean, you don't have to have witnesses or exhibits, but you can have a response to say, well, this isn't fair, or whatever you want to say. Otherwise, I just need to push out this hearing. I'm stuck.
I appreciate that, Judge, and I guess we've said it before. It is more important to do it right than to do it quickly if we have to have a trade-off here. And that includes fairness to everybody involved, including the court. And I would prefer that this not be kicked off, but we're realizing that we're 2 weeks, essentially 2 weeks or less away from these hearings, that apparently there are going to be a number of witnesses that nobody but the defendant knows who they're going to be and what they're going to try to say, and then we're expected to react in court. That's just simply not the way to operate an effective, efficient, fair process.
Well, let's explore this. I mean, how many witnesses are you expecting to have?
I'm expecting to have 2 on 16th. At this point in time, I'm not expecting either one of them to write a report. I expect a couple of exhibits. Some will be things from the protected materials that the court allowed us to have already. There will probably be 1 or 2 other exhibits, maybe 2 that the state hasn't seen before. I can provide those. I intend to provide those. On the hearing on the 14th, I think there may be 2 witnesses. On that hearing, 1 for sure, possibly a second. We haven't made that determination yet. If there is going to be any PowerPoint presentation, I will provide that to the state as well. If we have an expert who hasn't written a report, then we won't offer expert opinions. We'll offer opinions about why we know the discovery is available, why we know these items are available. The state knows full well what they have and what they're withholding from us. And it's not going to be about what they're going to show. We don't know what they're going to show, but we know they exist.
Thank you. Well, I just want to have this hearing. I don't want to push it out. All I can say is do your best. I'll be fair about it. I'll give you more time to respond if you still have that time. That's kind of where we are. And I just want to keep going. I mean, we got to get through all this discovery stuff so that we can get ready for the trial.
Well, and Judge, I do for the record need to clarify. The representations of the defense that we are intentionally withholding things that they're entitled to is just utter nonsense. We have strived. We are continuing every week to provide additional discovery. We have more discovery coming. We hope that much of what they felt they had to file a motion to compel on instead of being patient and wait.
Happy November. Whatever you do this month, don't feed the trolls or the feds. Don't let them feed you. Don't take the bait. Don't play with fire, but burn whatever bridges you need to burn.
Because our discovery deadline is in September, that we'll have and be able to make that available between now and the hearings on the 14th. And there may very well be little, if anything, we have to fight about. Your Honor also noted there are some things that we simply do not have the power to access. And we have been trying consistently through cooperative efforts as well as following the process with the federal government. They have been good partners, but they have their own rules to work with. This isn't the motions for the subpoenas due stecum isn't the first TUI process, and the court is aware. We've been pursuing TUI process for all types of information for months. So the characterization that we are just consciously withholding information to frustrate the defense is utter nonsense. That is not true. We will provide everything we can that is providable under the rules. If we disagree on something, whether it exists or not, because I can tell you, many of the things that the defendant is trying to itemize, when we talk to our people, they say that doesn't exist. So, I don't know what we're supposed to do at that point. We'll flesh it out in the hearing. And it may be that if they have experts who are going to say, well, such and such should exist, we might have to go find experts to say, well, in this case, it doesn't. Or no, we'll see.
Yeah.
Well, that's exactly why I want to close it on the 14th, because we're going to have many arguments, apparently, about issue by issue by issue. And some of that should not be out of it.
Thank you, Your Honor.
Your Honor, I want to respond to that. And I could give you particular examples of things. And it's already been ordered to be given to us, the CAST report, which was a draft that we were promised to have by March 31st. It's May 2nd. We don't have it. So for the prosecutor to stand up and say that I'm misrepresenting things, he's misrepresenting things.
I've been called all kinds of names, but I might be best known as a bridge builder. I do love building bridges. The thing about bridges is that every one of them is an invitation to people on the other side to come over and play. Some of those people might hate you. Some might just be simple or scared or naive. Some are enemies or trolls or federal agents who are best left under the bridge. Those are the ones who will try to steer and poison whatever you're doing if you let them come across. Every bridge could make you stronger, or it could destroy everything you want to defend.
But weighing that not just against, of course, his rights, but also against the needs of security in this case. I do expect, as it probably will come to no surprise to you, for you all to get along. I understand the stakes in this case are as high as they can possibly be in any case. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial. But you are professionals. You have taken oaths, both as of officers within your jurisdictions, but also as attorneys before this bar. So I expect at all times for you to remain civil to one another, that you not engage in personal attacks, ad hominem attacks, that you not engage in theatrics. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial. Not misstate the facts or the law to the court, and that when you cite arguments in your briefs, if there is contradictory precedent, I expect to see that. I appreciate in advance what should go without saying that I've just said in terms of your responsibilities, but again, I just want to highlight that because I understand when the stakes are high, sometimes victory seems to be the objective when our first objective is to conform to the oaths that we've taken as members of the bar, as officers of this court. I'll take the motions to suppress under advisement and issue ruling forthwith. The next issue is the state's motion to compel regarding the defendant's expert disclosures.
I'm sorry, Your Honor, the defendant's motion to compel the
Did I say the state's motion to compel? The defendant's motion to compel regarding the state's expert disclosures.
We did file ours yesterday, so their motion may be coming.
Well, I would be impressed if they had filed something already on that, given they were just served yesterday afternoon. So
They were. Thank you. Your Honor, we are here on our motion to compel, asking that the court remedy what the state has done with their expert disclosures. We rely on Idaho Criminal Rule 16 and the court's order setting out what we should do and when we should do it in this case.
And I would prefer that this not be kicked off, but we're realizing that we're 2 weeks, essentially 2 weeks or less away from these hearings, that apparently there are going to be a number of witnesses that nobody but the defendant knows who they're going to be and what they're going to try to say, and then we're expected to react in court. That's just simply not the way to operate an effective, efficient, fair process.
let me ask a question from a framework standpoint. I don't know what these folks are going to testify to at trial, specifically as it relates to what they've disclosed. The way expert disclosure issues usually works, I don't tell a party what you have to specifically disclose about your experts. You disclose about what you think you need to disclose. If you haven't disclosed it consistent with the rule and you try to offer it, there's a good chance it may not come into evidence. That's the general framework, so I'm a little, I guess, concerned about what appears to be you asking me to tell them what to say in their disclosures.
The court brings up a really, really good point. And I think it's a remedy the court has and one that we would hope and ask the court to issue in this case. I think when we filed the motion, Your Honor, we had a couple of disclosures that could appear to be disclosures with wiggle words in them.
Yeah, wiggle words are not going to save the lack of disclosure. I'll let the state know that right now. The fact that you say, well, you can talk about anything else, doesn't mean he's going to get to talk about anything else.
In an abundance of caution, we were worried about those words. I appreciate what the court's saying, and I'm going to make this really short. The lists are problematic for us. There are 4 or 5 experts with lists. I understand what the court said. I like what the
They
court
also
said.
have reports that they reference.
The lab people do have reports. I understand those are their opinions. When we're talking about, and I'm going to specifically talk to you about their disclosure number 7, it's an FBI agent, Douglas. There's a list of financial records that he collected and looked at. Other than that those records exist, there's not a report telling me what they mean to him at all. If he's limited to say, I collected these records, this is what we have.
I understand the state can correct me, is what I understand from the briefing is respect to that. I think that's the Amazon documents, correct?
Those were some of those documents, Your Honor. There are a lot of others.
Was his expertise was in extracting or reviewing the information and how those were sort of obtained electronically and then simply guiding through, well, this is a transaction on this date that does this, which is not necessarily expert testimony, it's simply testimony.
No, but I believe it's a different expert that they have to do that does not have a report.
But is that expert testimony? Let's just say a television, if for some reason that were to be important. And that this transaction demonstrates that this is Mr. Kohberger's account, this is Mr. Kohberger's credit card, and this is the purchase on Amazon. And that was delivered to this address associated with Mr. Kohberger.
Those are factual issues, Your Honor. It's when we get to what do they mean, or I put these things together and I've made this picture out of something. That when we get to opinion, I appreciate what the court's saying. It sounds to me like lists don't do it if you want to interpret a record. That's what we hope to hear. That's what I wanted to accomplish today.
Well, I think it's pretty clear. You cannot simply say an expert's going to talk about topic A, topic B, topic C, and then be able to give a host of opinions that fall within those topics. The requirement is to list what their opinions are and what they relied on to give those opinions. It's different than the civil rule. I don't think they have to give as much detail as the civil rule requires, but they have to at least give what the opinions are and I believe what they reviewed, as I recall the rule off the top of my head.
I believe the court's about right. There may be another term or two in the rule that's specific, but I hear the court loud and clear. I'll point out one last thing and stop because I think I understand how the court interprets these issues and these rules. When you look at page 9 of the state's objection to our motion, and in the second to last paragraph, they tell you that they will continue to supplement their expert responses based on later discovery or whatever they decide to use. That whatever they decide to use has me worried. So I wanted to bring that up. I appreciate the court saying the court's going to apply the court rules and the discovery rules and follow the case law, and that's all we want. Thank you.
And so that I'm clear, as the state's approaching to talk about this, in terms of supplementation, it's allowed. It needs to be seasonable, which means it has to be not just whole cloth new experts, for example, without good cause showing me why that's necessary. It needs to be seasonable in the sense of the timing of it based upon when the information was received, when it was determined it was necessary to supplement. And then obviously we'll look at that in relation to what may And then obviously we'll look at that in relation to what may prejudice the other side in terms of the timing of it.
Certainly, I understand that. Their discovery deadline has come and gone. Their discovery deadline has come and gone. If something brand new happens, that would be a different issue. I would assume we would deal with that then. It's when I read whatever we decide to use, that's very, very broad. That's it. Thank you.
I can keep this pretty short. I don't think that there's really much in dispute at this point. State's position, we've complied through our expert disclosures with Criminal Rule 16b-7, as well as your court's scheduling order. State understands the framework that you've outlined. We were under the same impression, and I don't think that there's anything else in dispute.
Yeah, so let me give you a word of caution. Sometimes there's dissonance between what an expert thinks that they're going to talk about and what the lawyer understands from that expert. And the lawyer submits these disclosures. And I think it's really important that you be on the same page if you don't have a specific written report from the expert about what it is they're going to talk about, and make sure that you have supplemented and that you have provided a listing of the opinions that are going to be provided and whatever else is required under the rule in terms of what that's based on. And I would encourage both sides to over disclose those opinions in caution rather than under disclose. Because two things. One, you may find yourself in a bad position if you're not allowed to go into an opinion you felt you were going to be allowed to go to because it's not disclosed. And two, I don't want to spend half our day at trial with me saying, where's that disclosed at? And then chasing the jury out while you dig through your thousands of pages trying to find where that is. And so the more exhaustive your disclosures, the less likely it is it's going to draw that objection, and the less time that we're going to waste at trial trying to find where you disclose that. And so I think sometimes, and I'm not saying you did that in this case, I think sometimes lawyers view this expert disclosure requirement as sort of tedious work that they need to get done in order to comply with the timeline, a requirement of the court, and then they sort of move on from it and forget about it. It's a dangerous tact to take. It is, for the case, one of the most important things that you can do is to understand what the person is going to testify to, and give a disclosure of what they're going to testify to, what those opinions are, and to be looking at that as you're thinking about their testimony, as you should be doing certainly now, even though it's months away from trial, on a continuing basis. So I would really stress the importance of that in a case, particularly of this import. And so don't feel like your job is done at this point, because I would suggest to you it's not. That you may consider needing to do some cleaning up and making sure things are more fulsome in the scope of those disclosures and what you're doing. The other thing, I think you tried to do to a degree is you thought, well, we think this is fact testimony, but in an abundance of caution, we're going to put it in an expert disclosure. Well, if you're going to put it in an expert disclosure because in an abundance of caution it could be viewed that way, I suggest you treat it that way in terms of what you give. Okay, thank you. And that goes to both sides. I haven't read your disclosures yet, so I don't know where that stands, but certainly goes to both sides. And I know that also, that the rules are different as to what the defense has to disclose necessarily and what the state does to some degree. And so I appreciate that.
Well, I think the court will anticipate that there's a rather large filing that contain a lot of actual reports. Your Honor, listening to the court's comments and understanding where we were a moment ago when we spoke, I feel like I must go through what their disclosures were because there are so many lists. My hope was that they would be limited because they didn't fulfill their disclosure requirement, and we did, and that put us at quite a disadvantage, not knowing what their experts would say.
And if they supplement, you certainly can supplement based upon what they supplemented, and I will permit that, and that's kind of the nature of the beast.
I do appreciate that, and should that become necessary, we'll definitely take you up on that, Your Honor. I want to make a record about some of their expert disclosures, though. All of the lab people, they have lab reports and notes. The Idaho State Police Forensics Lab, I better be really clear on that. Other than the wiggle room language, which would ask that they not be permitted to have any wiggle room language, the lab reports are fine, with the exception of one of the witnesses, Ms. Nowlin, that they've disclosed, and she's written no reports.
Is that the one they said is a rebuttal witness?
They said she might be a rebuttal witness, so I suppose now they know what our witness is going to say. I want to talk about the CAST report. The court's heard a lot about the CAST report. When I say CAST report, that's because that's what it's called. It's really a PowerPoint presentation. There's not any analysis in that. There's just, this will be my testimony this is what it's going to be, without much more. It's a picture, and it has some dots and some arrows. Your Honor, that needs to be cleaned up. We need to understand the analysis that went into coming up with those PowerPoint presentations. That's just not plain good enough. I would let the court know that the cell phone experts, there's wiggle language in both of those if the court hasn't seen that. Their disclosure number, that's Mr. Cox. That's a person that has not written a report at all. We have no idea besides the state's disclosure what that person's going to talk about. Agent Douglas that I talked about before, I don't think I need to make further record. There's a lot of documents, no analysis, no opinion stated.
And apparently there are going to be a number of witnesses that nobody but the defendant knows who they're going to be and what they're going to try to say, and then we're expected to react in court. That's just simply not the way to operate an effective, efficient, fair process.
We put several of these in our pleadings, and so I won't go through all of them. I'm highlighting the ones that we're really concerned about. We have 3 that looked at digital data. The court should understand there's 60 some devices. There's digital data from third-party sources, and there are 3 people that are listed with just lists of things. It's Mallory, Tenzel, and Uric. They have lists of devices or social media accounts that they're going to talk about. That our expert told us would take 3 years to look at every bit of the data. So having no clue what's going to happen, I can envision exactly what the court's fear is when we get to jury trial, me wondering if this particular thing was ever disclosed. So I definitely needed to make a record of that. Further, with the lab personnel, there's a caveat that says they'll talk about other people's reports and other things that are outside of their report, in addition to some of the other wiggle language that I referred to. Your Honor, given that the state is now cautioned to think about those things and submit more, I feel like it's important for us to bring out that we have a right to confront the evidence that's brought against us. Brian has constitutional rights, United States and state of Idaho constitutional rights for a fair trial and to confront evidence. The expert disclosures are designed to advise us of what the state is going to do. Their disclosures were insufficient. I appreciate what the court said, but exactly what the court's worried about will happen if we don't have better disclosures. The jury will be in and out while we make sure that we have a clean record. We appreciate what the court said today, and we'd ask the court to order the state to comply or for the court to exclude anything that hasn't been disclosed so far. That's it.
So I'm going to give like both sides an example of what I expect so that you understand. There's been talk in this case about DNA. If somebody's going to talk about DNA and your intent is they're going to let the jury understand what DNA is and essentially going to do a mini course on DNA, I expect to see that in expert disclosures. Not that they're going to do a mini course on the DNA. I expect to see the mini course in the disclosures, if that makes sense, in terms of what their opinions are, what their information is that they are conveying that is expert in nature. And so it really does behoove both sides to spend the time to do that. And that's the last I'll say about that.
I burned it all, but bridges, nothing burns quite like a bridge does.
And apparently there are going to be a number of witnesses that nobody but the defendant knows who they're going to be and what they're going to try to say, and then we're expected to react in court. That's just simply not the way to operate an effective, efficient, fair
Happy
process.
November. Whatever you do this month, don't feed the trolls or the feds. Don't let them feed you. Don't take the bait. Don't play with fire, but burn whatever bridges you need to burn. Oh, and thanks for being my neighbor. You can cross my bridge anytime you want, unless you're a Fed.